Now, you look at the 11.2c. Now, that gives you a definition of unsecured advance, unsecured loan, unsecured credit facility. All right. So again, that's self-explanatory. So I'll move on with that one. Right. Now, Part 5 of the FAA is with regard to the powers of the MAS. Right. And again, if you look at paragraph 12, so they have this power to approve the appointment of a chief executive officer and directors of licensed financial advisor. Now, the reason for this is again simple. They want to make sure that only fit and proper persons are appointed, right, to conduct financial advisory services and the market and sale of the designated investment products under the Financial Advisors Act. All right. So 12.1 says in Section 56A of the Financial Advisors Act says so, required to seek approval, okay, of the MAS under the submission of Form 11 for the appointment, right, for its chief executive officer or director, or when changing the nature of the director from one that's non-executive to one that is executive. Now, sometimes companies do appoint non-executive directors on the board, right? And sometimes companies also have what we call independent directors, all right? So when a non-executive director or when an independent director becomes executive, you also need to seek prior approval from the MAS, right? Now, and then A sets out the criteria to be for the appointment. So you want to be a CEO or director of a financial advisor corporation. Those are the criteria, right? So you can look at A that has been inserted under the amendment, all right, and all the way down to J, right? So J is quite interesting because whether there's any reason for the MAS to believe that the appointee or director will not conduct himself with professionalism or act in an ethical manner in discharging the duties that he is to perform as a chief executive officer, director, or executive director of a licensed financial advisor. Now, you may argue that this is very subjective, right? But I'm of the view that there must be some facts or circumstances in which the MAS have good reasons to believe so, right? For the appointment of a CEO or a director, right? So because CEO and directors are important people in a company, let alone in a financial advisor corporation. So again, it's self-explanatory from A to J. Okay, what are the criteria that intending person, right, who wishes to be a chief executive officer or director must meet before he or she can be appointed. Okay? And 12.4 say that there could be reappointment, right, without prejudice to the MAS power to impose conditions or restrictions as the case may be and from time to time, right? Right. So, so the power of the MAS is very broad in that regard. Now, B sets out the duties of the chief executive and director. Right? I mean, clearly, A say comply with all laws and rules governing the operation of the financial advisor company in a manner that is commensurate with the nature, scale, and complexity of its business. Right? Some licensed financial advisors are big, some are small, and the type of financial advisory services that provide also vary. So therefore, the duties must be commensurate with the nature and the scale and the complexity of the business. So 12.6 provide for an offense for contravention. Right? And then C provide for the criteria for determining if the CEO or the director has breached the duties. Right? Right? That's under Regulation 14 of the FAR. Right? Now that's in terms of the appointment of the CEO or the director, and also the duties of the CEO and director. Now, in relation to the removal of the officers of the licensed financial advisor, this is provided for under 13 in chapter 3 of your text. Right? So again, you can see 13.1, I just read to you quickly. The fit and proper criterion is a continuing requirement, underline that, right? At the point of appointment, you may be fit and proper, right? But during the course of your work or your function as a CEO or director, all right, he or she may have committed some serious breach, all right? So this requirement for fit and proper is continuing. So if the MAS of the view that any of these directors or CEO, they do not measure up, right? If these people do not measure up to the benchmark of fit and proper, then the MAS may direct the company to remove such officer from his office. All right, if he thinks it's necessary in the public interest or for the protection of the investors to do so. Right? So the fit and proper criteria is a continuing requirement. We will look at the what are the tests, right? The three main tests that the MAS uses to determine whether a person is fit and proper later on in this program. Right? So the powers are given to the MAS by law, all right, for the appointment, setting up the duties, and for the removal of CEO and directors of a financial advisor corporation. Now, 14 is actually an important point in terms of the power of the authority to issue written directions. Remember in chapter 1, I talk about written directions like, notices and directives and stuff like that, right? So here, this particular section 58.1 of the FAA, all right, provides that the MAS may, if it thinks it necessary or even expedient, all right, expedient in the interest of the public or a section of the public, or for the protection of the investors, issue written directions. All right. As I said before, written directions are binding. They are legally binding. They have the force of law. They have legal effect of a general or specific nature. So they can have written directions. They can have written direction to any licensed financial advisor, any person exempted under that section, any representative, any supervisor, any class of person. Okay, the powers are very broad. Right? They can issue written directions to all of those people listed there. Okay? And to comply, the word is comply with such requirements as the MAS may direct in the written directions or for any other purpose. And of course, here it's put written directions include a circular or a notice. Right? So a notice, as I've said before, is binding. Right? All right? And also, if you look at paragraph 15, the power to issue prohibition order. Now, I've talked about that earlier. All right. A prohibition order is to keep unfit persons from engaging in any or all of the financial advisory services regulated under the FAA. All right. Or taking part in the management of or acting as a director or substantial shareholder of a licensed or an exempt financial advisor. All right. So they will bar you from either acting in the provision of services or even in the management or running of the financial advisor corporation. All right, a prohibition order will be issued only in cases where the serious offences have been committed. Right. So A dash sets out the powers of the MAS to make prohibition order. All right. And then B sets out the effect of the prohibition order. All right. All right. And the third line there under 15.3, just pay attention to that. The licensed financial advisor or exempt financial advisor shall not, underline the word not, employ the person to provide any financial advisory services or use his services to the extent that is prohibited by the order. All right? It can be a general order, omnibus order, or it can be an order with specific directions. Right? And any financial or exempt financial advisor which contravenes this shall be guilty of offense and $50,000 fine maximum. Okay? So again, that is the power given by the MAS to issue prohibition orders. Okay? Now, section C there under 15C gives you gives the MAS the power to vary or revoke prohibition order under section 61.1 of the FAA. Okay? So MAS may vary or revoke a prohibition order by giving a written notice to the person against whom the order was made. All right. In other words, they remove the suspension. All right, as it were. If the authority is satisfied that it's appropriate to do so because of a change in any of the circumstances based on which the authority made the order. Right? So MAS must have very good reasons to make the prohibition order. All right? And if the MAS finds that, well, the circumstances have changed and there's a need to vary or to revoke the order, so MAS can do so under Section 61(1) of the FAA. Now, under Section 61(2), MAS may vary or revoke under subsection 61(1) of the FAA on its own initiative. MAS, after examining the PO after some time, PO is a prohibition order, on its own initiative may vary or revoke. Or if a person against whom the order was made lodges with the authority an application for the authority to do so, accompanied by such document or fee as may be prescribed. So the person who is given a prohibition order may apply to the authority, to MAS, to vary or to revoke the order. Of course, you have to furnish information as to why the PO should be revoked, should be varied, all right, or should be revoked, all right. All right. So MAS on its own initiative can vary or revoke the prohibition order, or a person under the PO can also do the same. Right, and then 15.6 talk about the MAS shall not vary a prohibition order made under a person without giving the person opportunity to be heard. Now that's again natural justice, right? So if you vary the order, right, or anything that do with the order, sometimes you have to give a person without giving the person opportunity to be heard. Right? And anybody who is aggrieved by the decision of the MAS, right, in terms of variation order, made against him can within 30 days, right, make an appeal to the minister. Right? Again, this is a natural justice principle thing. There's an avenue for any aggrieved person to make an appeal. All right. Then 16, very quickly, about the authority having the power to publish information. All right. So Section 67 gives the MAS the power to publish information, right, relating to any of the matters set out in A to H. All right. Lapsing, revocation, or suspension of license. All right. So MAS can publish this, all right, in relation to A, right? Removal of any officer, all right? You remove any director, CEO, you can also publish this, all right? Making out any prohibition order against any person, you can also publish. So it cannot be kept a secret. All this it has to be published, right? They have the authority to do so. All right, and then reprimand of any person under E. Say MAS give a warning or reprimand, it has to be published. A revocation or withdrawal of any exemption granted by the MAS under the FAA. All right. Conviction of any person for any offense under the FAA. Sometimes you see that in the newspapers. All right. So ABC, this ABC person has contravened a particular provision of the FAA, and therefore he's convicted, sent to jail. So you find this in the newspapers sometimes. But of course, this kind of information is not published by the MAS, it's published by the newspapers, all right? But the MAS has the power to do so. Now, conviction of any licensed financial advisor for any offense in Singapore as well or elsewhere, and any other action as may be taken by MAS against any person under the FAA. Okay, so again, the same issue. Necessary or even expedient to publish in the public interest. Okay, so this is an open season kind of thing in terms of the power of the MAS to publish information regarding all these things. Okay. Now then, the part 8 of the FAA under offences, that's in paragraph 17. All right, now this covers the persons who can be committed in terms of imprisonment term for any breach. So I just read to you under section 83 here says offense committed by a body corporate that means a corporation, a company, has been proven with the consent or connivance, all right, of or to be attributable to any neglect on the part of an officer of the body corporate. Now, I want you to underline this. Consent, of course, you agree to commit a particular offense, right? Or you agree to contravene a particular provision of the FAA or the FAR or the notice, all right? Or connivance of, or even to be attributable to any neglect, right? Negligence on the part of an officer of the body corporate. Now, that particular officer, right, whether you are a manager or whether you are a director, as well as the body corporate, shall be guilty of that offense and shall be liable to be proceeded against and punished accordingly. So not only the financial advisor corporation, the company, also the individual officer in charge. All right? So that person, that individual person can also be punished. That means you cannot hide under the umbrella of the financial advisor corporation. Oh, this is the company's business, nothing to do with me. Now, you will know that a company is just a legal fiction. It's just an entity, all right? It must be run and managed by natural persons. Decisions are made by natural persons, all right? And these are people whom we call officers, all right, of the company. All right, now Section 17(2) stated very clearly, in terms of the definition of an officer in relation to a body corporate. What does an officer mean? So the answer is provided under Section 83(5) of the FAA. It means a director, member of the committee of management, chief executive, manager, secretary, or other similar officer of the body, and includes a person purporting to act in any such a capacity. Mind this particular phrase, includes a person purporting to act in any such capacity. So if you hold yourself out as a director, as a secretary of the company, or as a chief executive, right? Therefore, you are a person purporting to act in that capacity. All right? Now, that's in relation to a body corporate. Now, an officer in relating to an unincorporated association other than a partnership, okay, means the president, secretary, members of the committee of the association, or a person holding a position analogous to that of a president, secretary, or member of a committee, and includes any person purporting to act in any such capacity. All right? So as I've said before earlier, end of the day is you need a person, a natural person, to act on behalf of a corporation, right? Whether it's incorporated or otherwise. Right? Now, throughout the FAA, various provisions have stipulated the penalty to the body corporate. All right? For example, obligation to furnish information, negotiation, and placement of risk with unlicensed insurer, and so on. Right? So these are corporate offenses. Right? Now, 18 provides for offense by the officers. Right? In addition to the penalty of the body corporate, Section 84(1) of the FAA says, right, that any officer of a licensed financial advisor who fails to take all reasonable steps, right, to ensure compliance with any provision of the FAA, any provision, all right, or the accuracy or correctness of any statement submitted to the MAS, or such other person has been required under the FAA. So now we are targeting natural person. All right, shall be guilty on an offense and shall be liable on conviction. You must be convicted by a court of law to a fine of not exceeding $100,000. All right. So therefore, if you are a director or a committee member, a management committee member, or chief executive or secretary of a company, or any other person purporting to act in that capacity, all right, if you contravene any of the provision of the Financial Advisors Act, then the liability upon conviction is $100,000 max, or an imprisonment term of not exceeding 2 years. All right, so there's a 2 years imprisonment term maximum. All right, or both. Okay, so so officers have to be very careful as how they conduct themselves in the business of the financial advisor corporation. Right? Now, of course, 18.2 gives you the defense on reasonable grounds, right? Now, 84, Section 84(2) says that in any proceedings against an officer under the paragraph above, it shall be a defense for the officer to prove. Right? I must say again, as before, the burden is on the officer to prove that he has reasonable grounds for believing that another person was charged with the duty of securing compliance with the requirements of the FAA, or with the duty of ensuring that those statements were accurate, as the case may be, and that that person was competent and in a position to discharge that duty. Now, sometimes I call this the arrow defense, right? End of the day, who is the person who is responsible in discharging the duties required under the Act? All right? So you can say that, look, it shall be a defense if you believe that another person, right, is responsible, not me, all right? And as such, then you have a reasonable defense, right? So therefore, in terms of practicality, most of the financial corporations, the licensed financial corporation will have a very senior committee or a person senior enough to ensure compliance with the provisions of the FAA, right? So that's why I think the legal and compliance people play a useful role in this regard, right? And having said that, I think training is also equally important to make sure that all the financial advisor representatives and all the officers are fully aware of the various provisions of the Act. Right? So that's one round of defense, all right, where you can prove that hey, say, look, I'm not the person in charge. The other person is in charge. All right, he's senior enough position. He is competent, well qualified. All right, and then he to secure compliance with the FAA. All right. So, and then 18.3 also give another round of defense. All right, we say that an officer shall not be sentenced to imprisonment, because imprisonment is a very serious thing, for any offense under the paragraph above, unless, in the opinion of the court, he has committed the offense, underline the word willfully. All right, he closed his eyes, he knows that it is an offense, and he willfully, he deliberately, recklessly commit the particular act, then the court will send this person to jail. All right. So there are two grounds of defense in regard to the officers of a financial advisor corporation, right? So he can point out to the fact that, look, this other person is in charge and not me. He has been paid very well. He has a team of people working under him, very competent, all right, senior enough, all right. So therefore, this is the person that is responsible for compliance with the provisions of the FAA. And of course, if a person is charged, then he has a defense to say, look, I did not commit the offense willfully. Okay, maybe it's a lapse of judgment or whatever that the person can come up with. All right. So the standard of proof, the standard of test is whether it's willful or innocent in not following the provisions of the FAA. All right. Now, 19 is serious in terms of the falsification of records by officers. Right. Now, Section 85(1) of the FAA says that any officer, auditor, employee, agent of a licensed financial advisor or an exempt financial advisor, example, bank, merchant bank, finance company, insurance company, and all that, exempt financial advisor. Again, the word is willfully. Who willfully, deliberately makes or causes to make a false entry in any book or in any report, slip, document, statement of the business, affairs, transactions, conditions, or assets of that financial advisor. All right. So you make falsification in all those things willfully, or if you willfully omit to make entry in any book, report, slip, etc., etc., willfully omits. That means deliberately you leave out. Okay. And then C, willfully alters, extracts, conceals, or destroy entry in any book. All right. So these are all very serious offenses. You want to destroy, you want to conceal, you want to change the records and slips and extracts and water and whatever willfully, then the penalty is the same, right? 100,000 maximum, 2 years maximum jail, or both. All right. So, yep. With that, I think I've come to the end of chapter 3. Well, I hope that has been useful for you. Thank you.